Not everyone on the Supreme Court agreed with the decision. While Justice Kagan was joined by Justices Roberts, Sotomayor, Kavanaugh, Barrett, and Jackson, Justices Thomas and Gorsuch both filed dissents, and Justice Alito joined with Justice Thomas. For this episode, I'm going to focus on the Thomas dissent. Jessica Shivarani sued several city officials for damages under 42 U.S.C. Section 1983. He alleged that they violated his Fourth Amendment rights by subjecting to a malicious prosecution. I continue to adhere to my belief that a malicious prosecution claim cannot be based on the Fourth Amendment. Accordingly, I would affirm the dismissal of Shivarani's claim. Justice Thomas believes that a malicious prosecution claim cannot be based on the Fourth Amendment. I must admit I was confused at first until I looked up the definition of malicious prosecution. As I've already quoted, the Free Legal Dictionary defines malicious prosecution as an action against someone for an unsuccessful proceeding that was started without probable cause. To raise a successful claim under 1983, a plaintiff must allege the deprivation of rights, privileges, or immunities secured to him by the Constitution. In this case, Shivarani claims that he was seized without probable cause in violation of the Fourth Amendment. Is it that Mr. Shivarani was seized without probable cause, or that his seizure was extended or enhanced because of a warrant issued without probable cause? A malicious prosecution claim bears little resemblance to an unreasonable seizure under the Fourth Amendment. Consider what is required to establish a claim of malicious prosecution. A plaintiff must show that 1. The suit or proceeding was instituted without any probable cause, 2. The motive in instituting the suit was malicious, and 3. The prosecution terminated in the acquittal or discharge of the accused. These elements have no overlap with what is required to establish a Fourth Amendment seizure violation. Did Justice Thomas read his own dissent? The Fourth Amendment clearly states that no warrant shall issue but upon probable cause, and that a malicious prosecution case also requires that proceeding without probable cause. How does that not overlap? The case against Mr. Shivarani was discharged, so the only element of a malicious prosecution left is to ask if the charge was malicious. Malicious prosecution is therefore not an appropriate tort analog for a 1983 claim alleging a seizure in violation of the Fourth Amendment. Again, I'm confused. A malicious prosecution case requires that a case be brought without probable cause, which is a prima facie violation of the Fourth Amendment. In a case where probable cause for one of the charges was not established, that involves a deprivation of rights under color of law, which is the purpose of 1983. The court's decision to forge ahead with combining the malicious prosecution and Fourth Amendment frameworks will inevitably create confusion. As I've explained, an unreasonable seizure under the Fourth Amendment requires a seizure. A malicious prosecution claim does not. It appears Justices Thomas, Alito, and I believe Gorsuch have a preconceived notion that malicious prosecution and Fourth Amendment claims are not only different, but never the twain shall meet, even if they both require a lack of probable cause. While a malicious prosecution claim may not require a seizure, it does not exclude it. How did the court find in this case?